सभासदों, माननीय उपसभापति जी,
सबसे पहले मैं अपने माननीय सभापति जी का मैं शुक्रिया अदा करती हूँ। आज पहला मौका मुझे मिला है और मैं आप लोगों का सहयोग भी चाहती हूँ। प्राइवेट मेंबर लेजिस्लेटिव बिजनेस बिल फॉर इंट्रोडक्शन, द मैक्रो स्मॉल एंड मीडियम इंटरप्राइजेज डेवलपमेंट बिल अमेंडमेंट बिल 2018, Dr. T. Subramanian Reddy. Absent. The Railway Amendment Bill 2018, Dr. T. Subramanian Reddy.
Absent.
The Employment Bill 2018, Dr. T. Subramanian Reddy. Absent. The Constitution Amendment Bill 2018, Shri Ripan Boraji.
Thank you, respected Madam. I beg your leave. I beg your permission to leave to introduce a bill for Constitution Amendment Bill 2018, insertion of Article 21B.
The question is that the leave be granted to introduce the bill. Those in favor will please say aye. Those against will please say no. I think the ayes have it. The ayes have it. The ayes have it. Shri Ripan Bora.
Madam, with your permission, I beg to introduce a bill for Companies
Introduce the
Amendment Bill 2018.
I introduce.
Madam, I introduce the bill.
Next, the Companies Amendment Bill 2018. Shri Ripan Boraji to move.
Madam, with your permission, I beg to introduce a bill, the Companies Amendment Bill 2018.
Those in favor will please say ayes. Those against will please say no. I think the ayes have it. The ayes have it. The ayes have it. Shri Ripan Boraji.
Madam, I introduce the bill.
The ancient monuments and archaeological sites and remains Amendment Bill 2018. Shri Sabha Chhatrapati.
Thank you, ma'am. I rise to move to leave to introduce a bill further to amend the Ancient Monuments and Archaeological Sites and Remains Act 1958.
The question is that leave be granted to introduce the bill. Those in favor will please say ayes. Those against will please say no. I think that ayes have it, the ayes have it, the ayes have it. Shambhaji Chhatrapati.
I move the bill.
The Contempt of Courts Amendment Bill 2018. Dr. K.V. Ramchandra Rao.
Respected Madam, I rise to move for leave to introduce a bill further to amend the Contempt of Courts Act 1971.
The question is that the leave be granted to introduce the bill. Those in favor will please say ayes. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Shri K.V. Ramachandra Rao.
Madam, I introduce the bill, madam.
The Criminal Laws Amendment Bill 2018. Shri Hussain Dalwai.
Adarniya Mahodaya, I move the motion to introduce a bill to amend the Indian Penal Code to make stalking a non-bailable offence given the large number of cases in which stalkers continue to harass victims after coming out on bail.
The question is that leave be granted to introduce the bill. Those in favor will please say ayes. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. This Shri Hussain Dalwai.
Madam, I introduce the bill.
The Prevention of Gender Pay Gaps Bill 2018. Shri Hussain Dalwai.
Madam, I move the motion to introduce a bill to address pay gaps arising out of gender discrimination and to prevent the same.
The question is that leave be granted to introduce the bill. Those in favor will please say aye. Those against will please say no. I think ayes have it, the ayes have it. Shri Hussain Dalwai.
Madam, I introduce the bill. I introduce the bill.
The Universal Health Insurance and Healthcare Coverage Bill 2018. Shri Narayan Lal Panchariya. Absent. The illegal immigrants identification and deportation bill 2018. Shri Narayan Lal Panchariya. Absent. The Information Technology Amendment Bill 2018. Shri Narayan Lal Panchariya. Absent. The National Tribal Education Board Bill 2018. Shri V. Vijay Sai Reddy.
Madam, I move for leave to introduce a bill to provide for the constitution of board for promoting and monitoring education and skill development of persons belonging to scheduled tribes and for matters connected therewith or incidental thereto.
The question is that leave be granted to introduce the bill. Those in favor will please say ayes. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Shri V. Vijay Sai Reddy.
Madam, I introduce the bill. Thank you.
The farmer's right to guaranteed remunerative minimum support price for agricultural commodities bill 2018. K.K. Ragesh.
Thank you, Madam. I rise to move for leave to introduce a bill to confer right on all farmers to obtain guaranteed remunerative minimum support price with minimum 50% profit margin over comprehensive cost of production upon sale of agricultural commodities and for matters concerned therewith or incidental thereto. Thank you, Madam.
The question is that leave be granted to introduce the bill. Those in favor will please say ayes.
Aye.
Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Shri K.K. Ragesh.
I introduce the bill. Thank you, Madam.
The National Capital Territories of Delhi Laws Special Provisions Bill 2018. Shri Sanjay Singh. Absent. Further consideration of the following motion moved by Shri Shukhendra Shekhar Rao on the 2nd February 2018. Discussion open. Shri V. Jayashai Reddy ji.
First of all, you want me to speak first, sir? First.
Hindi.
I'll support it if you. Ma'am, you want me to speak first? First of all, the member,
Ji haan, ji.
honorable member who has proposed the bill may. Okay. Thank you very much, ma'am, for the opportunity you have given to me. The objective of the bill is to reduce the ambiguity, the term consultation, and prevent its multiple interpretations. The bill aims to ensure homogeneity in terms of application of the term consultation to different provisions and interpretations by defining the term as the action or process of formally consulting or discussing with another is merely a consultative, advisory, and non-binding manner. Ma'am, in fact, I would like to refer some of the articles of the Constitution in this regard and also the backdrop. Article 124 of the Constitution deals with the appointment of Supreme Court judges. And Article 217 of the Constitution of India deals with the appointment of judges of High Court. Article 222 of the Constitution deals with the transfer of judges. In fact, ma'am, if we go through the status of appointments or nature of appointment or the way the appointments that have been made prior to 1993 was the President of India used to appoint the judges of the High Court and as well as the Supreme Court. And for the reason, and in 1993, the Supreme Court has delivered a judgment saying that the appointment of judges by the President of India has been being made with a political motives. Therefore, the Supreme Court has felt that there is a need to amend the procedure of appointment of Supreme Court judges as well as the High Court judges. Therefore, the Supreme Court has stated that a collegium system has to be appointed or introduced, and the President of India can, in consultation with the Chief Justice of India, can appoint the judges of the Supreme Court as well as the High Courts. Therefore, in 1993, the Supreme Court has introduced the collegium system in this country. Now, the CJI, if at all, what will happen if CJI is not concurring with the President of India? That is the question. If CJI is not concurring, then it will be referred to the collegium, and the collegium, if it reiterates the opinion of the CJI, the matter will be remitted to the President of India, and President of India will not have any other option but to accept the recommendations of the CJI. Now, what is the word consultation? The consultation, if you take it in the literary sense, it is not binding. When President makes an appointment in consultation with somebody, that consultation is nothing but an advisory in nature. When President of India consults the CJI, it is not binding on the President of India. The advice given by the CJI should be accepted, or it is his prerogative whether to accept or not to accept. That is the meaning of it. However, what is happening now is, see, there are two ways of doing it. See, proposal either can come from President of India, or the proposals can go from the judiciary to the President of India. There are two ways of doing it because Constitution doesn't specify anything. What will happen if so far, I don't think there is any precedent the President of India sending the proposals to the judiciary. In fact, on the vice versa, it has always been that the judiciary has been sending the proposals to President of India, and it is for the President of India to consult the CJI in this regard. And collegium decides, and the CJI sends the proposal to President of India, and President of India may sometimes accept and sometimes may not accept it. This is what is happening. So, the private member bill, what is now referred to, the honorable member would like to have probably the word consultation has to be more defined, and necessary amendments to the Article 366 is required to be made. That is the intention of the bill. Now, ma'am, see, to impart the objectivity and transparency in the process of selection of judges on the basis of norms rather than the subjective choices. This is what my opinion is. Considering the pitfalls of the events, when the executive decided, prior to 1993, as I have already stated, the executive used to decide who are to be appointed, who are not to be appointed as judges. So when the executive decided the composition of judiciary in the aftermath of emergency, and in the cases, and particularly in the case of Keshavananda Bharati, it is probably the Supreme Court was of the opinion that it is unwise for the House of the Parliament to decide, and because there is always a possibility of political motives in the case of appointments. Particularly, Madam, I would like to make a reference to the statement that has been made by the retired Chief Justice of India, Mr. Sabharwal. Mr. Sabharwal has stated that it is always good for the democracy that there is a little tension between the government and judiciary, so long as there is an acknowledgement of judiciary be left alone. It means that the independence of judiciary is to be maintained. That is the fundamental principle on basis on which this Constitution of India has been drafted. So now, let me refer to the NJAC bill. When NJAC bill has been accepted by almost all the states, including after Parliament has voted in favor of it, it has been referred to all the states, and then matter has been referred to Supreme Court, and Supreme Court has squarely rejected it, saying that for what reason Supreme Court has rejected it? Supreme Court has rejected and quashed this NJAC Act for the simple reason that, on the pretext that it is against the basic fabric of the Constitution. Now, according to me, the word consultation has to be well defined, otherwise it will lead to so many complications. Further, the appointment of judges, for example, any appointment of judges, whether it is a collegium system or some other system that is likely to be introduced, whether what is stipulated in the NJAC Act, whatever be the system, there has to be a transparency, there has to be a consultative process, and at the same time, the independence of judiciary has to be maintained. So now that there are some allegations that the collegium system is not being worked out properly, and there are some loopholes in that, and there are some infirmities in that, it has to be revised. Definitely, it has to be thought of, and the collegium system has to be revised now in accordance with the present structure and in accordance with the present situations. Therefore, I support the bill, and the word consultation has to be well defined, and whatever the bill as such I support with the observations what I have made in this regard. Thank you very much, ma'am.
Shri Bhupendra Yadav ji.
Respected Deputy Chairman, Madam, the present bill brought by Shri Sukhendu Rai ji raised some important issues. As we all know that the separation of power between the legislature, executive and judiciary is a foundational pillar of the Indian Constitution. The most significant manifestation of the principle of separation of power is the independence of judiciary, as we all know. But one of the issues plugging the judiciary is the legal controversy surrounding appointment of High Court judiciary. And this is not a new issue. Since 1969, there have been a debate and legal arguments surrounding the process of appointment. As we know, Article 124(2) of the Constitution, which says that every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal, after consultation with such of judges of the Supreme Court and the High Court in the states. In simple words, the President has to consult with the higher judiciary to appoint Supreme Court judges. A similar process is laid down under Article 217 for the appointment of High Court judges. Now, the fundamental problems, or sometimes it's mentioned in the present bill also, that what is the definition of consultation? Because the word consultation is not defined in the Constitution, but it appears in the various articles of the Constitution, Article 124, Article 217, Article 222, etc. Sometimes, in the absence of this definition of consultation, create an ambiguity. That is the reason the word consultation still continues to haunt the bar and the bench of this day. To understand the meaning of consultation, we have to look at the previous decision of the Supreme Court, because this is a particular aspect of the Constitution which is every time dealt by the Supreme Court. And this definition of consultation is started in 1969 judgment. In 1969, the Supreme Court, in a judgment titled Chandramoleshwar Prasad versus Patna High Court and other, on the issue of the transfer of an additional district and session judge by the state government without consulting the High Court, with regard to the word consultation, the Supreme Court broadly observed, and I quote, "Consultation or deliberation is not complete or effective before the parties make their respective points of view known to the others and discuss and examine the relative merits of their views." After this judgment in 1977, a similar issue of the transfer of High Court judge by the Government of India without consulting the Chief Justice of India come up before the Supreme Court in Union of India versus Sakalchand, Himmatlal Seth. Even in this judgment, Supreme Court discussed the intention of our constitution makers also. And in this particular judgment, the Supreme Court explained that the word consult implies a conference of two or more persons in order to enable them to evolve a correct or at least a satisfactory solution. It was further held, and it was mentioned in the judgment, now I quote, "The consultation must be to be real, substantial, and effective consultation based on full and proper material placed before the Chief Justice by the government. If the government departs from the opinion of the Chief Justice of India, it has to justify its action by giving cogent and convincing reason for the same. And if challenged to prove to the satisfaction of the court that a case was made out of for not accepting the advice of the Chief Justice of India." Broadly, this principle, again upheld by the Supreme Court in 1981 judgment, the S.P. Gupta versus Union of India, this is the first judge's case, as we know, relating to the issue of redistribution and transfer of the High Court judges. While a notification issued by the Law Minister, the Supreme Court, interpreting the term consultation categorically, held the opinion of the Chief Justice of India as merely consultative, and the final decision in the matter of appointment of judges is left in the hands of the government. After that, this 1981 judgment, and till the stages of S.P. Gupta case, it may be said that the consultation only meant non-binding opinion, discussion, and there was freedom of disagree with the advice rendered by the Chief Justice of India, so long as there was sufficient reason to do so. What was required was consultation, not concurrence. But after that, in 1991, the case of Subhash Sharma versus Union of India, the Supreme Court observed that the S.P. Gupta versus Union of India required reconsideration. This is the time when the Supreme Court changed the view which Supreme Court held in Sakalchand case, and the Supreme Court took a contrary view and held that the consultation with the Chief Justice of India was vital importance and his views must play a decisive role in the appointment of judges. The Supreme Court also depreciated the practice of state governments sending proposals directly to the Government of India without reference to the Chief Justice of States and Chief Justice of India. After this first judge's judgment, again the Supreme Court Advocate on Record Association Union of India judgment in 1993, that is the second judge's case, which reaffirmed the concept of judicial primacy in the consultation process and overturned the decision in SP Gupta versus Union of India. The Supreme Court held in the second judge's case, in the choice of a candidate suitable for appointment, the opinion of Chief Justice of India should have the greatest weight. The Chief Justice, in turn, was required to consult the senior most judges of the Supreme Court or the High Court in forming his opinion. The Supreme Court further held the selection should be made as a result of participatory consultative process in which the executive should have power to act as a mere check on the exercise of power by the Chief Justice of India to achieve the constitutional purpose. It is this judgment that led to the collegium system in the judicial appointment. After that, in the landmark judgment, which related with the special reference of number 1 of 1998, that is the third judge's case, the collegium system was affirmed by the Supreme Court, and here they confirmed that the consultation means the concurrence. And it was held that the Chief Justice of India was required to consult 4 senior Supreme Court judges for appointment of the Supreme Court and 2 senior High Court judges for the appointment of High Court. The decision also led down certain exempt situations where the decision of the collegium is not binding on the government, where the Chief Justice of India does not consult with the senior Supreme Court or High Court judges, where the candidate lack eligibility or whom norms of the consultation process are not compiled with. The government was also empowered to convey the Chief Justice of India reason for non-appointment of candidate recommended by the collegium, and the collegium would be bound to reconsider their recommendation. The 3 judges, this case led to intensive board debate about the ambit and scope of consultation, ultimately vesting the privileges of the judicial appointment exclusively in the collegium. After that, this parliament passed the NJSC case. The NJSC case was examined by the Supreme Court, titled the Supreme Court Advocate on Record Association versus Union of India. And in that case, the Supreme Court noted that the consultation was a 2-stage process. The first stage involved the consultation between the Chief Justice of India and his colleague constituting the collegium for making recommendation. The stage also involved participation of the executive for giving input on eligibility of the candidate. And the second stage, after the recommendations are made to the executive may object to the appointment for a strong and cogent reason. The Supreme Court then state, and I quote, what can be more meaningful consultation postulated by Article 124(2) of the Constitution. I mention all these cases because this debate started from 1969 till 2016. The third judge's case, famous cases of the Supreme Court related on the NJSC Act. Though the question may be rhetorical, there is still the meaning of consultation required more clarity. The Supreme Court has interpreted and reinterpreted the terms of number of times, often taking different views. The term consultation is still remains to be objectively defined. As a result, significant time and effort have been debating about what constitutes consultation, quite often creating an impasse between the judiciary and executive, especially after striking down the NJSC case. This has helped to delay in appointment, sometime in the process also. and it affects the judicial process also. Therefore, it is imperative that the terms consultation be defined, or the independence, integrity and transparency of judiciary in its trusted forum cannot be compromised. There is, however, the independent judiciary means that we are living in the check and balance system. If the terms consultation is interpreted to binding consultation, or if consultation involves primacy of opinion of judiciary over the executive, it would be negate the principle of check and balance enshrined in the spirit of Indian Constitution and confer power, unfettered power of the judiciary, enabling it to tower over both the executive and legislature. That is the reason the present bill, moved by Shri Sukhendu Rai ji as a private member bill, require more discussion. But one thing is very much clear, that judiciary is an institution to whom we are giving a power to protect our fundamental right. The judiciary has also power to declare any act or any action taken by the parliament if it is unconstitutional and if it is against the basic structure of this constitution. But there may be so many other routes are required for the maintenance of the integrity and independency of the judiciary. In my view, the need of the hour is to establish a transparent mechanism, more transparent, for the purpose of appointment of higher judiciary, which involves non-binding good faith consultation between the judiciary and executive. Though we already talked about the independence of judiciary, complete independence of judiciary definitely give a power to a judiciary to give free and fair judgment. We all are believe in the independence of judiciary, but today what is needed in our country, that we want a strong democracy with absolute independence of judiciary, but interdependence and coexistence between the legislature, executive and judiciary. And this for the purpose of this interdependence, our framer of our constitution makers use the word consultation, although it is not defined in our constitution. The present bills seeks to the amendment in the constitution and require the definition of the consultation by inserting a special clause in Article 366. I think so many things which are not only governed by a written word, by the convention also. To making our democracy more strong, we make our convention more strong. Every institution, either it's a judiciary or executive or a legislative, they respect to each other, they put their own Lakshman Rekhas, they maintain the check and balance system, and I think if we'll do this, we will make our democracy more strong. That is the reason this is the important bill brought by Shri Sukhendu Rai ji, but I feel apart from this amendment, we must be more relied on the good convention, a healthy convention for the democracy. This is my view, and I think because the word consultation is only defined by the Supreme Court in its own judgment 1969 onward, and every time judiciary whenever defined the word consultation, the definition of scope of consultation become much wider and wider. So there must be a one limit. I think that is the limit is the Lakshman Rekha, where every institution must introspect of their own Lakshman Rekhas. That is the important aspect of bill. Although I think this bill is a good, but Apart from the amendment of the Constitution, the self-introspection and the self-restraint is required to the each and every institution. Thank you very much.
D. Rajya.
Thank you, Madam. At the outset, I take this opportunity to congratulate our colleague Shukandu Sekhar Roy for bringing this, introducing and discussing this important bill. Madam, he has brought in his speech introducing the bill several issues which were already debated in the Constituent Assembly. Really, it was very much enriching and enlightening on various problems which we are confronting today. Madam, in a country like ours, the jurisprudence is always in a continuous evolution. Our society is a class society. Our society is a caste society. And we should try to understand the dynamics between law, class, and society. We should try to understand the dialectical relationship between law, class, and society. Because I have certain points to explain. It is true what our colleague Shukandu Sekhar Roy has tried to explain to the Parliament. That is, we should be clear about consultation and concurrence. Whether amending the Constitution, Article 366, will set right everything, that's a different issue. But we should be clear, because now it is all in evolution and new problems are coming. And Bhupender ji also spoke about collegium, at the same time transparency. About collegium, very learned judges of the country, very eminent advocates have spoken out very clearly. There is an opaqueness in collegium system. There is no transparency. And now, when we discuss the appointment of judges at higher level, there is a kind of memorandum of procedure, MOP, and that is between government and judiciary. Nobody knows what are the contents of this MOP. And all the time, communications go from this side to that side to this side. But we do not know what is exactly the MOP, what is happening. Recently, the law minister made a statement that the retirement age would not be increased. We hope so. That is the decision of the government. My point is at a different level. That is, when we discuss the appointment of judges, we should take into consideration the society as a whole. And I have quoted in the past also, there are judges who pointed out Indian judiciary does not have adequate social representation. There is a strong feeling with our people. There is no adequate representation for women. Madam, you are sitting in the chair. Madam, you are sitting in the chair. We are happy. We want to see more women in such more places. But the point is, there is no adequate representation for women in judiciary. How to do it? Because we need women. And there is no adequate representation to SC, ST and OBC. Minorities also. how to provide adequate representation to these sections. There is an argument all the time given, that is a very cynical argument, non-availability of suitable candidates, non-availability of meritorious candidates. I find it extremely difficult to buy that argument. After 70 years of independence, we should not give such a cynical answer. Whenever a question is asked about adequate representation to all these sections, that is the reply we get. Non-availability of candidates, no meritorious candidates. This is nothing but a very cynical response, answer which we should reject. And if we have will, we can. There are people eligible and meritorious. So, madam, what I am trying to say, in our judiciary should have adequate representation to, number one, women, and to all other sections, scheduled caste, scheduled tribe, OBC and minorities. Then only we can give confidence to our people to have, because the lost faith for our citizens is court or judiciary, and everything can fail, but judiciary should not fail. How to strengthen our judiciary, how to strengthen the independence of our judiciary, how to strengthen the neutrality of our judiciary so that people get justice in true sense. Justice in true sense. Why I have to underline this? After this two-member judgment of on Scheduled Caste, Scheduled Tribe Prevention of Atrocities Act, what I see, there is an increase in the atrocities, crimes committed against SC, ST across the country. Across the country. It doesn't confine to one state, across the country. And the problem is, I'm completing. The problem is, Dalits are killed, cases are filed, and it goes to lower court, to high court to Supreme Court. Finally, in many cases, accused are all acquitted, and they are released. But people were killed, died, and what is the justice to them? So this is the issue. What I am concluding, when our colleague has brought this bill, it is really a relevant bill at this point of time, so that we can define, redefine many things in order to ensure true justice and justice delivery system to our citizens. That is my suggestion. How should consider this? Thank you very much.
मनोज झा जी, आपको 4 मिनट वक्त मिलता है।
शुक्रिया ऑनरेबल डिप्टी चेयरपर्सन साहिबा। I read the proposed bill and I find these are the times when, setting aside every concern, it is time for us to look at this entire issue. All of us may be with fresh eyes and fresh ideas. When in the month of January, 4 honorable judges of the Supreme Court held a press conference, and they said a couple of things. And those things were very alarming in nature. कि लोकतंत्र खतरे में है. I'm reminded of Dr. Bhimrao Ambedkar in 1943 in Mahadev Govind Ranade lecture, memorial lecture. उन्होंने एक बात कही थी कि लोकतंत्र सिर्फ वोटिंग का नाम नहीं है. संस्थाएं और संस्थानों के बीच में जो एक वाइब्रेंट कोलैबोरेटिव मैकेनिज्म है, वो लोकतंत्र को जिंदा रखता है, वरना लोकतंत्र के बीमार होने में वक्त नहीं लगता. उन्होंने एक बात कही थी कि अगर इन संस्थाओं का चरित्र हमारे समाज के चरित्र का प्रतिनिधित्व नहीं करता है, तो लोगों को, मुआफी के साथ कहूंगा कि लोगों को एहसास होता है, एक एहसास कमतरी होता है कि फलानी संस्थानों में हमारा चूंकि प्रतिनिधित्व नहीं है, तो हमारी बात नहीं समझी जाती है, हमारी संवेदनाएं नहीं समझी जाती हैं। किसी से ये शिकायत नहीं है, लेकिन ये प्रश्न है हम सब के लिए। कल भी मैंने एक संदर्भ में कहा था कि हम सबको दलों के दायरे से ऊपर उठ करके एक बार सोचना होगा कि जुडिशियरी, हायर जुडिशियरी में बहुत एक व्यापक ऐसे बदलाव की जरूरत है जिसको अंबेडकर साहब कहते थे कि राजनीतिक लोकतंत्र का ट्रांसलेशन अलग अलग स्फीयर में होना चाहिए। मैंने अभी जब पढ़ा, मैं मुबारकबाद देना चाहूँगा सुखेंदु जी को, क्योंकि हम में से बहुत लोग चर्चा नहीं कर पा रहे हैं इसकी खुल करके, लेकिन अब ये वक्त आ गया है। एक संदर्भ और मेरे समक्ष है, और वो संदर्भ है कि 2010-11 में हॉलीवुड की एक फिल्म आई थी द ग्रेट डिबेटर। पहली बार सर मैडम मुझे यह एहसास हुआ, मैं लिंच शब्द से वाकिफ नहीं था, क्योंकि इसका जुडिशियरी से मतलब है। पता चला कि रॉबर्ट लिंच नाम का एक सचमुच का व्यक्ति था, और 1960s में उसकी खाल उघेड़ ली गई थी। फिर वहां एक बयार चली बदलाव की, कुछ बदलाव मुकम्मल उन्होंने हासिल कर लिए। हमने भी कई बदलाव हासिल किए हैं मैडम, लेकिन कई बदलाव के लिए हमारा रवैया ढुलमुल कर रहा है। मैं आपके माध्यम से, सदन के माध्यम से, मैं मुबारकबाद को आगे तक ले जाते हुए कहूंगा सत्ता पक्ष से भी कि ये जो लोकतंत्र को एक व्यापक इंद्रधनुष बनाने की एक कला होती है, वो किसी की थाती नहीं है। ये सदन तय करेगा, और सदन जब तय करेगा तो सदन जनता के प्रतिनिधित्व के आधार पर यह बताएगा कि ये हमारी संस्था अब ये मकबूल हो गई, ये संस्था हमारे सामाजिक चरित्र का प्रतिनिधित्व करती है। आखिरी टिप्पणी मैं मैडम आपके माध्यम से ये करूं, कई दफा लगता है जब हम अंधी गुफा से गुजरते हैं तो जुडिशियरी रोशनी का एकमात्र सुराग होता है। मैडम, उस सुराग को मकबूल रखने के लिए, जिंदा रखने के लिए, बरकरार रखने के लिए जरूरी है कि रोशनी के उस सुराग में सारे रंग हों, वो इकरंगा ना दिखे। दिक्कत आज ये है कि थोड़ा इकरंगा है, इसको बहुरंगा बनाए, और ताकि जो हमारे मुल्क की विविधता है वो उसमें आ सके। थैंक यू वेरी मच मैडम, शुक्रिया बहुत बहुत। मैंने समय एक्सीड नहीं किया, बिल्कुल।
बहुत बहुत शुक्रिया। ऑनरेबल मिनिस्टर।
Madam Vice Chairman, Honorable Member has brought for amendment and bringing a definition under Article 366 of the Constitution of India by way of inserting the word consultation under Article 366 5A. I appreciate the bill is very good, no doubt, and I also extend my thanks to all the members who have participated. Mr. Sukendra Sekhar has raised a very important point, and thereafter Mr. Ramakrishna, Honorable Member Ramakrishna also spoke on the issue. Mr. V. Vijayasai Reddy also spoke on the point, and Sri Bhupendra Yadav ji and Honorable Member Dr. D. Rajya. So all the members, almost except one, this Ramakrishna, all have supported, and except Bhupendra Yadav, they have supported the bill. And so far the word consultation is concerned, it appears in various provisions of the Constitution of India, and we see that the consultation word has been defined by the Supreme Court, so far as it relates to Article 124 and 217. But consultation with the President of India while providing appointment to the High Court and Supreme Court judges as provided under Article 124 and 217, which means the concurrence. So if we see the word consultation appearing in various provisions of the Constitution, it also provided the word consultation in Article 124 like, and it reads, it is with respect to the appointment of the Supreme Court judges. So every judge of the Supreme Court shall be appointed by the President by warrant under his hand and sealed after consultation with such judges of the Supreme Court and the High Court. So there is no provision for this collegium system under this article. And again, Article 127, which provides appointment of the ad hoc judges in the Supreme Court. And it is provided that with previous consent of the President, and after consultation with the Chief Justice of the High Court concerned, the judges of the High Court can be appointed and Supreme Court can be appointed. So for this purpose, under Article 127, the previous consent of the President is mandatory. Then again, under Article 124, the retired judges of the sitting of the Supreme Court judges can be appointed by the Chief Justice of India, that too after the previous consent of the President of India. And Article 217 relates to the appointment of the High Court judges, and that too after consultation with the Chief Justice of India. And from transfer of the judges, it also provides the word consultation from one High Court to another High Court. The consultation is required if the Chief Justice and other High Court judges are transferred from one place to another place. So for appointment of the additional and acting judges in the High Court, then again the consultation of the President is also required and consent of the President. So retired judges can also be appointed with the previous consent of the President. So there is a difference if they are appointing the retired and ad hoc judges, then the previous consent of the President is required. But for appointment of the judges under Article 124 and 217, the consultation of the President is required. So use of the word consultation and previous consent of the President, it shows the intent of the constitutional framers. And further, Article 103 and 192, these are very important articles which require the decision on question as to disqualification of the member. So before giving any decision on such question, the President shall obtain the opinion of the Election Commission and shall according to such opinion. So here the President have no discretion. So under Article 103, on the basis of the opinion rendered by the Election Commission, the President has to pass the order. So President has got no discretion under Article 103. But so far as the analogous Article 192 is there, the President is again, the Governor is again required to pass the order as per the order of the Election Commission. So reading of all the provisions make it clear that the word consultation is appearing not only in few of the provisions, but it is appearing in so many other provisions also, like Article 98, Article 118, Article 148, 187, 208, 229, 233, 234, 324, 341, 342, and 370. So, and again, Article 143 provides reference by the President of India to the Supreme Court for giving opinion. So, if we read all the articles together, then only under Article 124 and 217, we see that in subsequent the judgment given by the Supreme Court, the word consultation has been defined, but the word consultation has nowhere defined with respect to the other articles. So if we see the history, then the first judge case of the S.P. Gupta, where the Supreme Court taken the view that the word consultation does not mean concurrence, it is only an opinion. But the second judge case in 1993, and in that judgment, the Supreme Court opined that the word consultation means concurrence. And the third judge case, where the reference was made by the President of India under Article 143 to the Supreme Court to give the opinion whether the word consultation is concurrence or not, and so many other issues were also referred for the opinion of the Supreme Court. The Supreme Court gave the opinion in the year 98, 99, and in that opinion, the Supreme Court gave the certain directions. Now the question is, the opinion formed by the Supreme Court under Article 143 is binding or not? And again, those opinions are basically consultation and opinion. If those opinions are binding, then certainly the word consultation is missing in the Constitution under Article 366. While framing the Constitution, the word consultation could not be defined. So this is no doubt, and thereafter the government brought the National Judicial Commission Act, and as well as the Constitution was also amended, and the provision under Article 124 and 217 were amended, and under that the National Judicial Commission was constituted. But that was challenged before the Supreme Court, and that was declared ultra-vires. Both the act and amendment was both declared ultra-vires and set aside by the Supreme Court. I would also like to refer the observation of the constitutional framers, Dr. Ambedkar, with respect to the word consultation, because some of the objections were also raised at the relevant time with respect to the use of the word consultation and what is the meaning of this word. So it is quote, the first is how the judges of the Supreme Court to be appointed. Now, grouping the different amendments which are related to this particular matter, I find three different proposals. The first proposal is that the judges of the Supreme Court should be appointed with the concurrence of the Chief Justice. That is one view. The other view that the appointment made by the President should be subject to the confirmation of the 2/3 vote by Parliament. And third suggestion is that they should be appointed in consultation with the Council of States. With regard to this matter, I quite agree that the point raised is of the one greatest importance. There can be no difference of opinion in the House that our judiciary must both be independent of the executive and must also be competent in itself. And the question is how these two objectives could be secured. In Great Britain, the appointments are made by the Crown without any kind of limitation whatsoever, which means by executive of the day. There is the opposite system in the United States where, for instance, the officers of the Supreme Court as well as other officers of the state shall be made only with the concurrence of the Senate. It seems to me in the circumstances in which we live today, where the sense of responsibility has not grown to the same extent to which we find it in the United States, the draft article therefore steers a middle course. It does not make the President the supreme and the absolute authority in the matter of making appointments. It does not also import the influence of the legislature. The provision in the article is that there should be a consultation of persons who are ex hypothesis well qualified to give proper advice in matter of this sort, and my judgment is that this sort of provision may be regarded as sufficient for the moment. With regard to the question of the concurrence of the Chief Justice, it seems to me that those who advocate that proposition seem to rely implicitly both on impartiality of the Chief Justice and the soundness of his judgment. I personally feel that no doubt that the Chief Justice is a very eminent person, but after all, the Chief Justice is a man with all the failings, all the sentiments, and all the prejudices which we as a common people have, and I think to allow the Chief Justice practically a veto upon the appointment of judges is really to transfer the authority to the Chief Justice, which we are not prepared to veto the President or the government of the day. I therefore think that is also a dangerous proposition. So in view of this, the word consultation was used under Article 124 and 217 of the Constitution, but the Supreme Court has given the meaning because it seems that the word consultation has not been defined under Article 366 of the Constitution of India. Madam, I would also like to refer about the fourth judgment and the opinion of the Justice Verma at the relevant time. Because the working of the collegium system, because so far as the collegium system is concerned, there is no doubt no provision under Article 124 and 217 of the Constitution of India for providing collegium. But in the relevant time, the Justice Verma has also spoke that I would also like to read that. He was also of the view that he observed that the collegium system has completely failed. And thereafter also, the Atal Bihari Vajpayee's government, the NDA headed by Atal Bihari Vajpayee, appointed a national commission. And the national commission and also has given its report on this issue. I would also like to read that, the relevant part of that report also. It is pertinent to mention that in its 21st report, the Law Commission of India under the chairman of Justice D.A. Desai submitted in July 1987, one of the aspects dealt with was a forum for judicial appointments. The report recommended the appointment of a National Judicial Service Commission for selecting and recommending persons for being appointed to the superior judiciary. The Law Commission recommended that the National Judicial Service Commission should comprise of 11 members, with Chief Justice of India as the chairman and the 3 senior most judges of the Supreme Court, a retired Chief Justice of India, the three Chief Justices of the High Court according to their seniority, the Law Minister, the Attorney General, and outstanding academic as a member with the provision to co-opt the Chief Justice of the High Court concerned in case of appointment to the High Court. So again, the report also, the NCRWC constituted, which also stated in the report that it would be worthwhile to have a participatory mode with participation of both the executive and judiciary in making such recommendation. The Commission proposes the proposition of the Collegium, which gives due importance to and provides for the effective participation of both the executive and judicial wings of the state as an integrated scheme of the machinery for appointment of judges. This Commission accordingly recommends the establishment of the National Judicial Commission under the Constitution. The National Judicial Commission for appointment of the judges of the Supreme Court shall comprise of the Chief Justice of India, Chairman, two senior-most judges of the Supreme Court and member, the Union Minister of Law and Justice, member, one eminent person nominated by the President after consulting the Chief Justice of India. So, in view of this report, the 99th Amendment was brought in and the Article 124A was introduced along with 217. But this amendment of NJAC and the Constitutional Amendment was struck down by the Supreme Court. But after that, even this one of the contempt proceeding pending before the Justice Chalamesar and Justice Ranjan Gogoi, they observed that the collegium system has failed and we are required to revisit the collegium system. So in overall situation, we see that since the word consultation could not be defined at the time when the Constitution was framed, when the Constitution was enacted under Article 366 of the Constitution of India, so this, I think this is the reason that these judgments are there and the field has been occupied by the judicial pronouncement. Now this is a very important bill, but since this is the bill which required the discussion with various stakeholders who are concerned about it, and we want all eminent persons, we are required to discuss with them, and thereafter we are required to frame our opinion and view, and thereafter we can only bring the legislation. But at this stage, I think I request my learned friend that he may withdraw the bill, and I assure him that certainly at appropriate time, we will discuss with various stakeholders, and thereafter we will come to a particular opinion, and thereafter we can come with the legislation. Thank you very much.
Shri Shekhar Rai ji.
Thank you, Madam. In fact, when I initiated this bill, I explained before this House that what prompted me to bring out this private member bill. And I am grateful to Mr. Ramakrishnan, who has since retired, Mr. Vijay Shah Reddy, Mr. Bhupendra Yadav ji, Sri D. Raja, Sri Manoj Kumar Jha, and of course the Honorable Minister. All of them have elaborately and eloquently dealt with the provision of the bill. It's a very simple bill, but has got a very significant impact on the present situation which is prevailing in our judicial system. On the last occasion, I elaborated as to how the word consultation has been used in different articles of the Constitution, and the Honourable Minister has also reiterated it and explained the consequences if in each and every article where this word consultation has been used, if that means concurrence, then there may be a stalemate in many areas, and the government may not function properly if each and every article which incorporates the word consultation, it means concurrence. That is why I said, Madam, I believe that what the Honourable Minister has said, that I also concluded on the last occasion that this issue should be kept alive and more discussion should be held on the issue before arriving at a finality. It's a very serious issue. My limited point of moving this bill was that an amendment to Article 366 of the Constitution, after Clause 5, the following clause shall be inserted, namely, consultation means the action or process of formally consulting or discussing with another in merely consultative, advisory and non-binding manner. That is very important. If the President of India is bound every time by some other organizations or institutions, then the head of the state, which is actually the central government, elected by the people of India, it will be a negation of the democracy, because in a democracy, will of the people is supreme. And when that will is reflected through the elections and the largest party or the largest group, they form the government, then such compulsion, if it is thrusted upon the government through an interpretation which is non-est, even in the eye of law, because constitution maker never opted for that. And I mentioned in my last speech today also, the Honorable Minister has said. Now, I'm just pointing out only two, three things. I will not take so much of time. Madam, what should be the approach while interpreting a word? First of all, in a nutshell, I would like to mention the Legal Research Foundation Legal Research Methodology, published by Allahabad Law Agency in 1997. They made a thorough research on this by referring to different court cases of the English court as well as the courts of India. And it says, only few lines, if the words, I quote, if the words given in the statute are lucid and explicit, it is not for the judges to go beyond that language or words to try and establish what the legislature might have meant by using that word. It is also known as a grammatical interpretation. The courts have to follow this principle, even if it results in irrationality, or even if it is contrary to the policy or intention of the legislature. It does not look beyond it means the court does not look beyond the litera legis, which means letter of legislation. It just looks at what law says. Words and phrases are to be construed by the courts in their ordinary sense, and the ordinary rules of grammar and punctuations have to be applied. Unquote. Then again, in Supreme Court, our Supreme Court, what they say, only two lines. In the matter of Bengal Immunity Company Limited versus State of Bihar, reported in the All India Reporter in the year 1955, Supreme Court, page 661, I quote, the Supreme Court observed, it is also well settled that interpreting an enactment, the court should have regard not merely to the literal meaning of the words used, but also take into consideration the antecedent history of the legislation, unquote. Now, this is a different view, which I said earlier, that is one view. This is another view, which Supreme Court has said. Now, Supreme Court wants that not only the ordinary meaning, it should also take into consideration the antecedent history of the legislation. Then what is the antecedent history of the constitutional provision? The word consultation, in what premises? The framers of the Constitution, they incorporated the word consultation in different articles of the Constitution. Just now the Honorable Minister has explained, right from Alladi Krishnaswamy Iyer, an eminent lawyer of Madras, who was a member of the Constituent Assembly. He actually proposed that the judges of the Supreme Court and High Courts should be appointed by the President of India in consultation with the Chief Justice or senior two judges. Now, there were contrary views, as rightly pointed out. Some said, no, not only consultation, there should be concurrence. The third view was two-third majority in the both houses of Parliament. It will be decided and they will be appointed by the Parliament by way of two-third majority of both the houses, as it is prevalent even today in Switzerland, where the Swiss Federal Court appoint the judges of Swiss Federal Assembly, appoint the judges of the Swiss Federal Court. So that was the third view also. Ultimately, Dr. Ambedkar said, it has a balancing act, no. There should be a participating process between the executive and the judiciary, and therefore, consultation is required, no concurrence. Therefore, this is the antecedent history of the legislation. This is the antecedent history of the provision of the Constitution and the word consultation. Finally, it is a settled principle. This is Hillsbury's Laws of England, reported in the Hillsbury's Laws of England, 4th edition, volume 44, para 864. I quote 2-3 lines. It is a settled principle of interpretation that the court must proceed on the assumption that the legislature did not make a mistake and that it did what it intended to do. Therefore, in a good faith, the words to be interpreted, even if there is some mistake, it should be the intention of the legislature should not be questioned. If the result of the interpretation of a statute by this rule is not what the legislature intended, it is for the legislature to amend the statute rather than for the courts to attempt the necessary amendment by investing plain language with some other than its natural meaning to produce a result which is otherwise thought the legislature must have intended. Therefore, the court cannot import another meaning of an ordinary meaning of the word which is relevant in the context. Therefore, madam, the way in our country things are being interpreted, things are being dealt with, it is not only reprehensible, but it is dangerous for this democracy to run. No authority can function. In our democracy, powers have been given to different authorities, not to enjoy for themselves, but to exercise those authority for common good. Therefore, the common good factor is to be kept in mind. But I am sorry to say, in some cases, this common good factor is absent and the authorities are exercising the powers for their own interest. I am against that. So once this bill is accepted today or tomorrow, if the government brings a legislation, comprehensive legislation on this, I shall be the happiest person that at least I try to invite the attention of this august House that something should be done. The time is ripe that something should be done. Based on the assurances given by the Honourable Minister in this regard, I would like to withdraw the bill with the permission of this august House. Thank you, Madam.
I would like to know whether this has been recorded as an assurance and taken as an assurance and referred to the assurance committee in case if it is not adhered to.
Quorum नहीं है. Quorum नहीं है.
बिल विड्रॉ कराएगी पहले.
श्री सुखेंद्र शेखर राय जी. Shri Shikandar Rai ji, are you withdrawing the bill or should I put the motion to vote?
As already stated, since the Honourable Minister has promised that the matter will be discussed here and some action will be taken, I may be allowed to withdraw.
Has he leave of the House to withdraw the bill? Now the bill is withdrawn.
मैं बताता हूँ.
काउंट करके बता. इसको बताओ.
अगर आपको कोरम का इशू उठाना है तो पहले उठाओगे ना आप. पहले को
जब विड्रॉ होता है, अभी कोरम ही नहीं है।
पहले कोरम का इशू उठेगा तब जाके होगा, अभी तो विड्रॉल हुआ है। अब आप कोरम का इशू उठा रहे हैं तो उसको काउंट कर लेते हैं।
रुक जाइए, वो समय में क्या किया जी? सदन की कार्रवाई सोमवार 23 जुलाई 2018
लिख के आ रहा है, लिख के आ रहा है,
11 बजे तक की जाए।
लिख के दे रहा है, वेट करेंगे।
बिल बना। अगले हैं।
अभी नहीं जोशी
सदन में क्योंकि कोरम नहीं है, अतः सदन की कार्रवाई सोमवार दिनांक 23 जुलाई 2018 11 बजे तक स्थगित की जाती है।